Good morning and welcome to this, the third webinar in the autumn series being hosted by St John's Chambers. My name is Charisse Crawford from Scown and I'm going to chair the session today. I just have two housekeeping points to go through and then we'll jump straight into the session and the speakers themselves. The first point is feedback. We are operating in an ever-changing world and St John's are obviously hosting these seminars in hope they are of some use to us. So if you enjoy the session today, please feel free to complete the feedback form. It can be in the chat function or on the follow-up email that will be sent post this session. The second point is that today's session is a live and interactive one, so please feel free to upload your questions during the session itself. But don't panic if we don't answer your question straight away. We will pick it up in the Q&A section at the end of today's session. So without further ado, I'm going to hand over to our first speaker. We have 4 speakers today. They will each speak for approximately 15 minutes and then we will have a Q&A section at the end of the session. So over to you, Josh.
Thanks very much, Charisse. Good morning, everyone. Today is going to be a 15-minute race through invalidity claims on the grounds that the testator lacked knowledge and approval of the will and its contents. Knowledge and approval claims are something of the ugly duckling in will validity claims. The real superstars seem to be lack of capacity and undue influence. And in my experience, knowledge and approval often seems to get either bolted on as an alternative claim at the end, or in other cases missed out entirely. And my aim today is to bring it forth into the light and make sure it is at the very least properly considered when you're investigating a claim for invalidity. In particular, we're going to be looking at the case of Middleton and Borman, a 2020 case from here in Bristol, in which to really draw out the duck-related analogy. The claimants very much put all their eggs in the knowledge and approval basket. So we all know the basics. The knowledge and approval is really the question of, did the testator actually know what they were signing? But it's important to untangle it from capacity claims. Can you have capacity but lack knowledge and approval, and vice versa? The answer to both those questions is yes. In capacity claims, it's important to remember that the question is not whether the testator did know or did meet the B&G test, but is whether they were capable of understanding the necessary elements of the Banks and Goodfellow test. So looking at Buckingham and Dickinson, this is a useful case for drawing out the separation between the two. In this case, the testator obviously had capacity. It wasn't in serious dispute, but he was totally blind, totally deaf, and almost entirely blind as well. And so the question at hand was whether enough had been done by those around him in order to bring the contents of the will to his attention and understanding. And on the facts of that case, that hadn't been displayed, so he lacked knowledge and approval of the will. What is less obvious is whether you can lack capacity but still know and approve the contents of the will. The answer to that question, again, is yes, and useful case here is Simon and Byford to explain it. Testamentary capacity includes the ability to make choices, whereas knowledge and approval requires no more than the ability to understand and approve choices that have already been made. That is why knowledge and approval can be found even in a case when the testator lacks testamentary capacity at the date when the will is executed. Key phrase here, at the date the will is executed. What the court is doing is drawing a distinction between instructions given for the will and perhaps the will being signed sometime later. So if you have capacity at the time instructions are given, as long as you know and approve or are capable of knowing and approving the will at the later date, then you will meet the test for capacity. Moving on to presumptions, there's a school of thought of which I'm very much a subscriber, that presumptions in will validity claims are purely academic, whilst it's technically impossible to envisage a capacity claim where the judge might fall back on the presumptions. In reality, claims don't exist in a factual vacuum. The judges have repeatedly said it's about the evidence, and they will make a decision on capacity on the basis of the evidence that is put before them. And that's a similar type of point that the Court of Appeal seemed to be driving at in Gill and Woodhall, where it was said that considering all the relevant evidence available and then drawing such inference as it can be from the totality of the material to come to the conclusion whether or not those propounding the will have discharged the burden of establishing that the testatrix knew and approved the contents of the document. So what we seem to have there is discharging burdens, so burdens being on the propounder of the will, but actually the court saying, look, we're going to look at all the evidence and make a decision one way or the other. But actually, it's not quite that straightforward. And in my view, in knowledge and approval claims, there's a little bit more to the presumptions than there might be in, say, capacity claims. So that's why we see in Gill, again, the Court of Appeal saying, as a matter of common sense and authority, the fact that a will has been properly executed after being prepared by a solicitor and read over by the testatrix raises a very strong presumption that it represents the testatrix intentions at the relevant time. This derives from Fulton and Andrew, where it was said that if the testator's competent mind had read over the will to him and thereupon executed, those circumstances afford very grave and strong presumption that the will has been duly and properly executed by the testator. So if you're defending these claims, and you've got a will where instructions were given to a solicitor, the will was read over by the solicitor to the testator or testatrix, then that's going to be a pretty strong burden for or presumption for the contesters to overturn. It's important to note that this strong presumption in Gill and Fulton and Andrew doesn't apply where the person who prepared the will is also a beneficiary under it. That's because those types of wills are inherently suspicious. A useful case for that is Re A Solicitor, which is a 1974 case. Slightly further down the scale as well is Hawes and Burgess. That was a case where there was a solicitor involved, but quite a lot of the instructions in answering of the questions came from the person who became the beneficiary and ultimately the propounder of the will. And also there was no evidence that the will had been in fact sent through to the testator before she signed it. If you are trying to contest under a knowledge under a knowledge and approval basis, the case of Gallagher is also a useful case. In that case, the court said a radical departure without good reason requires positive evidence that the testator knew and approved the contents. Quite a good one to rely on if you're met with this strong presumption of Gill and Fulton and Andrew. So taking a step back, what are knowledge and approval claims particularly good for? Well, the answer to that is dodgy will claims, where a will comes out of the woodwork, no one seems to know of its existence before, and it is on its face surprising, particularly so if it wasn't prepared by solicitors in consultation with the testator. In that case, it's a really good bet because some of the difficulties in capacity and undue influence cases are avoided. In those cases, you as the disputer are really having to make the running, but in a knowledge and approval case, it's the propounder who has to show that the deceased had knowledge and approval. All of which brings us on to Middleton and Borman. As I said, this was a Bristol case. It wasn't the local Chancery Judge, His Honour Judge Matthews. It was a Deputy High Court Judge, James Pickering, QC. In this case, Mrs. Brewer, who is the deceased, had 5 children from 2 different relationships, one marriage, one partnership. She executed a mirror will with her final husband, who wasn't the father of any of the children. The survivor will give their entire estate to the 5 children in equal shares. However, in 2014, after the husband died, she executed a new will, giving the overwhelming majority of the estate to her youngest daughter. So 4 of the children were claimants. The other child was the defendant. But there was another key figure who was the defendant's son, i.e. Mrs. Brewer's grandson. The facts of the case are pretty extraordinary, but they often are in these types of cases. And in reality, it's a classic case of Mrs. Brewer being buffeted between either side of her family. Just looking through a few of the key elements here, we can see that the claimants arranged the funeral of the husband. The grandson then installed himself as a joint signatory to Mrs. Brewer's bank account with Mrs. Brewer's assistant. The grandson also arranged the revocation of the claimant's power of attorney, and he took the deceased to the will draft to get a new will, was present through most of this meeting, albeit not all of it. The claimants then assisted the deceased in transferring money from the joint account, which it appeared the grandson had been dipping into a sole account purely in Mrs. Brewer's name. It was also recorded at the meeting with the bank where this new bank account was being set up that Mrs. Brewer was doing it, in her words, to stop that bastard getting my money. That bastard, it was presumed to be the grandson. But no sooner has this bank account been set up than the grandson intercepted the PIN when it was posted to Mrs. Brewer, and then the defendant and the grandson arranged for a new power of attorney in the defendant's favour. And then there was an extraordinary series of events where the defendant and the grandson clearly lost confidence in the will drafters where the will was stored. This resulted in 4 separate incidents. Incident number 1, defendant and grandson attend will drafter's office unannounced and try and get a copy of Mrs. Brewer's will. They were, for obvious reasons, refused. Incident number 2, a few days later, Mrs. Brewer and the grandson went to the will drafter's office asking for the will. The will drafter got a bit fed up, took Mrs. Brewer into a room, talked to her for a period of time, and she then signed a letter of authority saying that actually what she really wanted was the will to stay with the will drafters. And she was quite happy for them to look after it. And then finally, incident number 4, the will drafters receive a signed letter of approval, ostensibly from Mrs. Brewer, asking for transfer of the will to the new solicitors. This series of events is fairly extraordinary, but it also shows the virtue of getting a seed and planting it in the judge's head. The way counsel for the claimants portrayed the 3rd incident, i.e. when Mrs. Brewer attended the offices herself, was that she had fluffed her lines that were given to her, i.e. She'd been told to say something by the claimant and her son, and she failed to do so when she was in a room by herself. And you can see the judge in the judgment coming back again and again and quoting this line of Mrs. Brewer fluffing her lines, and it really had a positive impact from the claimant's point of view at the end. Now, it's important to note that for some reason, an undue influence claim wasn't brought in this case. Instead, all that was advanced was a lack of knowledge and approval claim. And the judge looked through all these incidents in relation to the power of attorney, the flip-flopping over who was going to take the will, the bank accounts, and so on, and said, is this a case of the deceased changing her mind, flip-flopping again and again? I think not. Is this a case of the deceased being forced or unduly influenced into signing documents she did not really want to sign? Again, I think not. Instead, once again, so I find, the deceased was willing to sign whatever important documents were put in front of her by a member of her family, whichever one it was, without any real appreciation of the detail and effect of what she was signing. So far, so good. But remember, what was really an issue here is the signing of the will. And the judge said, after some deliberation, that he could safely conclude that actually there was no knowledge of an approval in relation to the will as well. He said, as has been clear from the tugs of war over the bank accounts, the recovery of documents and powers of attorney as set out above, however, the deceased appears to have always been prepared to go along with whatever family member she was with at the time without necessarily appreciating the detail and effect of what she was doing. And that's an easy enough case to make in relation to the power of attorney and the bank accounts and so on. It's a lot harder, it seems to me, to make in the case of the will signing, because even though the grandson was present during some of the, at least some of the time, in reality, Mrs. Brewer wasn't active passively. There was a period of time where she gave instructions to the will drafter alone and unaided. It was also clearly the case that she was capable of changing her mind when she was alone, as she demonstrated when she fluffed her lines later on. It seems to me that there's a distinction between certain events where she was acting passively and the signing of the will, where it seems she took a more active role. Now, the judge spent some time talking about the later event when she signs it, which came a few weeks later, and suggests that this was just put in front of her and she signed it, which is true. But at the same time, it's got to be viewed, in, it seems to me again, in the context of her giving instructions previously. So when one takes a step back and asks the question, well, can it really be said that Mrs. Brewer didn't understand the contents of the will when she gave instructions to it? It seems to me that that's quite difficult, but that's what the judge found in this particular case. And the very punchy decision, it seems to me, of not at least including an undue influence claim alongside paid off in that particular case. But that's not always the case. Coles and Reynolds, very recent case, His Honour Judge Matthews again in Bristol, taking an entirely opposite view. I won't read this through because we're slightly short of time, but in essence, he fell back on the very strong presumption that if the will instructions had been given by the testator, that it had been read through to her by the solicitors, then it seems pretty unlikely that you're going to get away challenging on the basis of a lack of knowledge and approval. I suggest what really influenced the judge in the Middleton and Borman case was the fact that the grandson and the defendant were clearly up to no good one way or the other, and that an undue influence claim hadn't been brought. So in conclusion, where are we with knowledge and approval claims? Well, in my view, they are an extremely useful tool, particularly in dodgy will cases. But even if in some circumstances where the solicitor has been involved with attendance notes, Middleton and Borman shows us the benefits of pleading lack of knowledge and approval alongside either a capacity or undue influence claim. Thank you very much. I'm now going to hand over to Alex.
Joss, thank you very much indeed. Ladies and gentlemen, I'm going to speak to you, if I can bring up my slides. I'm going to be speaking to you about the likely rise in claims based on faulty remote execution of wills. Let me just see if I can bring up my slide. Emily, are you able to bring up my slides, or maybe not? Anyway, let me give you an introduction while the slides are being produced. Ladies and gentlemen, there we go. You'll be aware that the Wills Act has been amended to allow wills to be witnessed remotely. And there's been quite a lot of press about this, unsurprisingly. Primarily, though, that press has been from a private client lawyer's perspective and has focused on the practicalities of how, as a will draftsman, you might go about drafting a will under this new regime. But I'd like to look at matters from a slightly different perspective, that is from a litigation perspective. Because this new regime, it seems to me, will give rise to new and fertile sources of dispute. and it's inevitable it's going to give rise to a new line of litigation for us contentious probate lawyers to get stuck into. So let's have a quick look at the amendment itself. I will be able to, there we go. Which I shall get to. There we go. So the amendment itself is set out here. It's an amendment to Section 9 of the Wills Act 1837, and its effect is essentially to introduce a new subsection 2. And the purpose of that new subsection 2 is to amend the definition of the word presence that's found in subsections 1C and 1D. And it amends the word presence to include presence by means of video conference or other visual transmission. So C and D are both concerned with the witnessing of wills. Section 1C is dealing with the testator signing in the presence of the witnesses who have to be present at the same time. And 1D is concerned with the witnesses then signing in the presence of the testator. But one point to note is that the word presence also appears in section 1A as well. It's got to be in writing and signed by the testator or by some other person in his presence. That's in the testator's presence and by his direction. So that word presence, where it appears in section 1A, is not amended to include video conference or other visual transmission. And so the effect of the amendments is that the testator cannot remotely direct someone to sign the will on his behalf. If he's going to go down that road, the person who's going to be signing the will on his behalf has to be physically present with him in the same room, or so it seems. Now, in a way, that's a bit of a shame, because it would have been very useful for a testator to be able to direct, say, the solicitor draftsman to sign on his or her behalf. The solicitor draftsman could be in the same room as the witnesses. It could all be done pretty conveniently. But the powers that be thought that that might be a step too far and might allow an opportunity for fraud or undue influence to arise. So that's not being changed. So the only amendment is to C and D, and this amendment is going to apply retrospectively back to 31st of January 2020. There's a couple of minor exceptions I'm not going to deal with, and prospectively to the 31st of January 2022, although that's a bit of a movable feast and will be changed depending upon how we get on with the coronavirus. So, useful sources of information. The Ministry of Justice guidance was updated in August of this year, and that's available at the gov.uk website, and it sets out 5 steps that they suggest you should go through if you're following this new regime, which is all very helpful. The step briefing note, dated back in July, goes through the same 5 steps but in more detail, and also offers some very helpful best practice tips, and that is, in my view, the most helpful of the notes. We've then got the Law Society guidance. The Law Society was slightly late to this particular party. They only published their guidance a couple of weeks ago, but it's written in a very accessible way, as you'd expect, and it deals with matters in a very practical way, so definitely worth a read. So what I'm going to do now is just go through 7 areas where I think a litigator might find themselves getting involved in all of this. The first is that there is a danger, it seems to me, that anyone who tries to use this new regime may think that the amendments go further than they do. And I suspect that this is probably more aimed at lay people trying to do it rather than solicitors. We've looked at section 9(1)(a) and noted that the testator cannot remotely direct someone to sign on their behalf. So that's a trap for the unwary, because some people might think that that is possible. It's clearly not. Secondly, this all has to be done in real time. You can't pre-record the testator signing and then email a copy of the video to the witnesses, who can then watch the video and say they've witnessed the signing. That doesn't work. It's got to be done in real time. You can't use counterpart wills. I think there is, in some jurisdictions you can. I think in New Zealand you're being allowed to use counterpart wills, but not in this country. So Again, from a practical perspective, that's a bit of a shame, because it would have been very helpful if I, as the testator, could have signed one counterpart will, and then the witnesses on the other end of my Zoom call could then sign their counterpart will, and the two counterparts would both form a single document. But it was felt that that, again, gives rise to too much opportunity for fraud and undue influence and so on. So it's got to be the same document. But what that means is that the will, once it's been signed by the testator, has to be physically sent to the witnesses. And if the witnesses are in separate locations, after the first witness is signed, it needs to be sent again to the second witness. So this will is going to be a well-travelled document by the time it is finally executed by all the parties. The final point is that the signatures have to be wet signatures, that the new regime does not allow electronic signatures. The Law Commission are reviewing the whole question of electronic signatures, and so there might be some developments on this, but for now, everyone's got to sign with a biro in the old-fashioned way. Second possible source of litigation, clear line of sight. Now, this goes back to the now famous case of Casson and Dade that we're all familiar with, where it was held that a will can be witnessed through the window of a carriage, provided that the witness has a clear line of sight of the testator, or in that case, testatrix, when he or she signs the will. And the same applies in this new regime. The Ministry of Justice guidance puts it pithily. By law, it says the witnesses must see the will maker, or someone signing at their direction on their behalf, signing the will. Before signing, the will maker should ensure that the witnesses can see them actually writing their signature on the will, not just their head and shoulders. I was involved in a mediation yesterday where my client announced, when he was signing finally the settlement agreement we reached, "Alex, you can see me signing this." And it was interesting because he then put it down on his desk and signed it. And of course, as soon as it was down on his desk, it went out of view of my Zoom screen. So I could see his head while he was signing it, but I couldn't actually see the document he was signing or his pen being written. Now, he wasn't signing or witnessing a will, so it's not a problem. But one can easily foresee that in a similar situation, someone might sign where the actual signing is done off screen, although someone's head is still on screen. That is not good enough. You've got to actually see the pen hitting the paper. The other issue here is glitches in the video link, screen freeze, etc. The step guidance very sensibly suggests curing it by acknowledging the signature. So if there's a screen freeze while I'm signing my will, I hold up the signed will and I show it to the witnesses and I say, look, I have signed the will. I acknowledge my signature, and that should cure the problem. But if it's not done, then potentially there is a problem. Third issue is delay. We've talked about this need for the will to be well travelled between the testator and the witnesses, and potentially between the witnesses themselves. Delay is therefore, as it were, baked into the system. And if the testator dies before both witnesses have signed, then obviously the will is going to be invalid. And that's a real problem because by definition, you're probably using this whole regime because you're dealing with a testator who's elderly or otherwise in a vulnerable group. And so if they die, as you are busy sending the wills around to the witnesses, it's going to be difficult for you to say that that was a completely unexpected turn of events. So White and Jones type negligence claims, it seems, are going to be a very real possibility. Fourth, the attestation clause. As you know, if you execute a will in the normal way, it has a standard attestation clause, which presupposes that the will has been witnessed in the normal way. If, however, you're witnessing matters remotely, you've got to use a different attestation clause, because if you don't, then the very useful presumption of due execution, which arises out of an attestation clause, will not apply. And that will allow contentious probate lawyers to then start arguing that this has not been duly executed. So the Law Society has given us a precedent, which I set out here, and it's really paragraph 2 that's the important paragraph, which simply recites that you've done it in accordance with the new amended section 9. And if you do that, there will be a presumption of due execution, which will be difficult to rebut. Fifth issue is that it's going to be pretty difficult, it seems to me, to comply with the so-called golden rule. And obviously, this has been hitting a lot of press at the moment with the Lord Templeman case, where Lord Templeman, who devised the Golden Rule himself, did not comply with it when his will was made, or his solicitor didn't comply with it when his will was made, and yet his will was upheld as being valid. So it's pretty difficult to comply with even pre-COVID, and in my experience in practice, quite often it's not complied with. Certainly the second limb of asking the doctor to act as one of the witnesses, that's pretty unusual in my experience. But I do wonder whether, in fact, remote medical consultations could be easier. If you've got a GP who's used to using Zoom, then you might be able to carry out a remote medical consultation and capacity assessment, which could be perhaps more easily done than it would in normal times. But I remain of the view, well, my experience remains that getting a doctor to act as the witness is going to be very difficult. The sixth source of litigation, in my view, the most interesting one is the fact that a lot of this remote witnessing will be videoed. It's not actually a requirement under the new regime, but all of the three guidances that I've given you, Ministry of Justice, STEP and Law Society, all speak with one voice and say it's pretty sensible to video this if you can. And if you do, it should provide clear evidence of capacity. Lord Justice Lewison said in Simon and Byford that he approved a passage in an Australian case, I'm not going to read it out in an Australian accent, as tempted as I was to do so, where it was said that perhaps the most compelling evidence of understanding would be reliable evidence, for example, a tape recording of a detailed conversation with the deceased at the time of the will, displaying understanding of the deceased's assets, his family, and the effect of the will. Well, that should be what you get if you video the process here. It can also provide direct evidence of undue influence, and as all we contentious probate lawyers know, it's terribly difficult to get direct evidence of undue influence, and that's why you normally have to infer it, which is the point that was made in Schrader and Schrader. But if we've got videos, suddenly here we have direct evidence potentially of undue influence if it is indeed happening. So it can be jolly useful. There are some disadvantages to using it for the will draftsman. What's happening off camera, a clever defendant can make sure that only certain things are shown on the video, whereas others aren't. And it seems to me that it completely changes the dynamic, because whereas the court's usual approach, as in Hawes and Burgess, is to say, well, if a solicitor says that the testator had capacity, who am I to doubt them? And I'm not going to pay much regard to medical experts who speak after the event. That may change if the judge himself or herself can actually see a video of the event, and indeed if the expert can see a video of the event, and suddenly we can all be in as good a position as the solicitor to judge whether the deceased had capacity or indeed was subject to undue influence or knew and approved of the will. Lastly, undue influence and fraud. The fact that the testator is by definition physically separated from the witnesses and the solicitor creates an obvious risk of undue influence and fraud. You need to check that the document that is being signed is indeed the will that you are expecting it to be, and it's suggested that you should hold up the will and show the witnesses what you are signing if you are the testator, and vice versa. It's probably sensible to sign, or at least initial, all of the pages of the will to make sure that no new pages are inserted after the event. Anyone who is unfamiliar with anyone being present should ask for proof of identity, and it may well be worth asking for a video tour of the room that the testator or witness is sitting in before you start the process, with any unexpected person sitting in the room introducing themselves and explaining their presence before you start the process. So those are the seven areas that I've come up with. There may be more that you can think of. We are, it seems to me, going to be getting some case law on this at some point. I don't think we've got any case law yet at the moment, but it will be coming down the line. So I look forward to speaking to you about it as and when it arises. But until then, that's all, folks. Thank you very much for listening to me, and I'm now going to pass over to Adam, I believe.
Good morning, everyone. I'm just making sure I've got control of the slides. My name is Adam Boyle. The title of my talk this morning is A Beginner's Guide to Domicile. I nearly called it an idiot's guide, and then I thought that probably didn't reflect very well on myself. As you'll be aware, It's quite a short race through everything this morning. I'm hoping to get across the essence of domicile and why it's an interesting existence in the law. So I thought, what better way to start something hosted remotely with all this technology than a quote from a poem written around 1700. The quote is, "Thus from a mixture of all kinds began that heterogeneous thing, an Englishman." It's from a poem called The True Born Englishman, which actually was an ironic title. The whole point being that that's not really possible. And as well as just breaking up all of this law, I thought it was an interesting way to start, because it raises the question, what is it to be English? There's lots of different ways to be English or to belong to one nation or another. And in that sense, it's quite close to the issue of domicile, which is a weird existence in the law. It's not quite nationality. You can acquire it lots of different ways. And it's about being affiliated with one country or another. So there we go. What is domicile? Well, the Cambridge English Dictionary gives a pretty simple answer: the place where a person lives. But this is oversimplistic, certainly not what we mean when we use domicile in law. The legal meaning is far closer to an idea of nationality or belonging, as touched on in the poem, and it certainly imports a greater than transient meaning. And actually the time spent by a person in one country or another has a limited relationship to whether they're domiciled there. For example, we can imagine someone saying, perhaps proudly, "I was born in France, but I've always counted myself an Englishman." As we go on to see a little bit later, there's more than just bluster in a statement like that. Potentially, it could have some basis in the law. So, domicile in law. Domicile has no statutory definition. It's a common law concept which connects an individual to the legal system of one country as opposed to another. A key theme in the law of domicile is the idea of a permanent home. So that's something we'll return to, but permanent home is something to have in mind. And domicile in law is clearly very different from just the dictionary definition of somewhere that you live or place of residence. And I thought, again, hitting the old school quotations pretty hard, I look at this cryptic assistance we get from someone called Lord Cranworth. Bear with me on this, because I've chosen it half because it is a bit weird and wonderful. And the quotation reads this: "By domicile, we mean home, the permanent home. And if you do not understand your permanent home, well, I'm afraid that no illustration drawn from foreign writers or foreign languages will very much help you to it." I'll pause there because Lord Cranworth, in his wisdom, decides to quote what I said, what is a foreign language being Latin, in order to try and help us to it. So he's kind of gone against his own rubric there. But the quote continues: "I think the best I've ever heard is one which describes the home as the place." And he says, "I believe there is one definition in which the lares or household gods are alluded to." Now, I'm getting a Harry Potter vibe from that. I don't know about you. I'm thinking of house elves. Then he quotes some Latin, but in 1858, of course, it would have been rude not to. And the Latin translates as defining permanent home as the place from which you cannot be separated if nothing removes you. And when you depart from there, you're seen as a stranger. He says that's the best illustration rather than definition. And I know this is a bit of a weird and wonderful quote, and I find it quite impenetrable myself, but I quite liked it for that, because domicile is quite weird and wonderful. It's a strange idea. And I particularly liked the bit where he says, "a place from which you cannot be separated." And I think he doesn't mean that physically, because obviously you can move from one place to another. I think what's interesting here is this abstract connection between a person and a place that means that even if they go somewhere else, they've not been separated from their country of origin. That's quite a nice idea. And equally, I think there's a different translation from when you depart from there, you're seen as a stranger, and it's actually when you depart from there, you're seen as absent. So it's a place that when you go away, you're missed, or you're absent, and even when you do go away, part of you hasn't been separated from there. It's a nice idea. It's quite ethereal. Doesn't make loads of linear sense, but that's domicile for you. Yeah, Lord Cranworth, I think, helps get to the nub of the issue, which is this idea of belonging, identity, or affinity with a place is key to domicile. And again, it's the same kind of thing which might allow somebody else to say, well, the kind of thing we'd read in a novel. Of course, I haven't been to London for 40 years, but I still consider myself to be an Englishman. Okay, so there are three types of domicile: domicile of origin, domicile of dependency, and domicile of choice. And domicile of origin works like this. Everyone has a domicile of origin at birth. This is based on their parents' domicile. It's usually the father, probably for patriarchal reasons in history. And if the parents are married at the time of the child's birth, that's when the child will take the father's domicile. If they're unmarried at the time of birth, or the father has passed away, the child will take its mother's domicile at the time of its birth. Everybody does and everybody must have a domicile at all times in their life. And if you lose your domicile of choice, we'll go on to what domicile of choice is, then the domicile of origin can resume. And in essence, it means that your domicile of origin, the place where you're initially from, never quite leaves you. You can replace it with something else, but that replacement, if it fades away, it reverts back to your domicile of origin. So here, very quickly, if you get somebody, if you imagine somebody goes away on holiday, or works away from the UK for a few years, they have a child, the child's born somewhere that isn't the UK, that child's domicile of origin is still England. Okay, domicile of dependency, sort of linked to the idea of a child having the domicile of its parents, which I was just touching on. A person who, in the eyes of the law, is dependent on another has the domicile of the person on whom the law considers he or she is dependent. So for children under 16, that's their parents, either the father or the mother, as just discussed, or those with certain mental incapacities. And when I was researching some of the finer points of this, I was quite shocked to find that until 1974, married women were treated as dependents of their husbands and acquired their husbands' domicile on marriage, which really shows. I see Charisse in my corner of my eye shaking her head. It is crazy to think that's not very long ago, and shows how far the law has come. Okay, domicile of choice. Unsurprisingly, this relates to a domicile status of an individual, result of their personal election or choice. To acquire a domicile of choice, two things are required: actual residence in the new country and an intention to reside in the new country permanently and indefinitely. Both of these things have to be present at the same time. A very long holiday doesn't suffice. As we touched on before, an abiding and permanent home is required. I'm not going to dwell on this slide because I think there's a more fun one a little bit later. This is all of the factors. So there's a big part of the law of domicile is the crazy cases where the courts have tried to decide whether you live one place or another, and whether you're domiciled rather one place or another. And there's a whole huge array of factors that have come into play. The more obvious ones include buying a house, or renting a house in a country, marrying a national of the country, moving your spouse there, having a business there, and all that kind of stuff. You think, okay, that makes more sense. Slightly more strange ones include voting somewhere. That makes more sense, makes some kind of sense, but the form and contents of a will, desire to be buried somewhere, decision to educate children in the country, learning the language, societal habits, and membership of clubs have all been factored in previously. And I'm going to read this quotation in relation to the case of Adams, which is a fantastic case where an Irishman served in the English Navy, married 2 English women, retired a commander in the Navy, moved to the south of France, spent his summers sailing his own yacht around the Mediterranean. Then when he died, there was a big question, where was he domiciled? So the quotation goes as this: as regards the testator's attitude to France, Miss Hutchings says that it was that of a dweller in a foreign country who took no part in French life. As to this, it would appear that he did not Gallicise himself. That's an interesting idea, Gallicising himself, but it has to be borne in mind that when he went to France, he was 67 years old and unlikely at the age to take on a new mode of life. The most natural thing to expect, whatever motive took him to France, would be that he would mix with Irish or English people, of whom there must have been many in those parts. She says that he told her that he was bored with living in the south of France. I think in lockdown England, none of us can think that could possibly be true, and that the French people bored him. There's much evidence to the contrary, and then the reference to 2 French clubs, the Club de la Voile at Villefranche, a sailing club, and a yacht club of Paris. Okay, so it's a strange concept, domicile, where even the clubs that you're a member of could factor in to the decision by a court about where you end up being judged to be affiliated with. A few more, I think I've got enough minutes to talk about this, but a few more interesting points on that case. This guy, this sailor, had said to his own bank manager that he was a proud Irishman. He'd said he never obtained a domicile of choice. He also expressed other views to the contrary at different parts of the evidence put before a court. He'd been domiciled in England for a certain purpose, and basically all of the evidence was all over the shop, and the courts, looking at things such as his clubs, decided that he had actually died domiciled in France. Okay, very quickly, English or British. Domiciled in England means in England as distinguished from Scotland and Ireland, because of course we've got our own slightly different legal system. And again, rounding everything up, why is domicile significant? First thing is it's a huge factor about what tax you pay on death. If a person is domiciled or deemed domiciled in the UK, that person is liable to pay UK inheritance tax on all of their worldwide assets, which is pretty huge. Those of you watching will be no doubt very familiar with the Inheritance Act. It requires an individual to have died domiciled in the UK, i.e. England and Wales, in order to have application. There's some marriage and divorce issues it's relevant to, and of course issues concerning the validity of wills, or rather the way the wills are construed and the conflicts of law. I'm going to put up a flag here that Nicholas Poynton, I think, is talking on conflicts of law next week, so you'll probably get more juicy stuff from him in relation to these issues. But just to highlight how important it can be, the guy who I was just talking about in the French domicile case, when the courts found that he died domiciled in France, they found that the French law applied to his estate, such that the forced heirship rules of France governed the way his estate was to be dealt with, and his daughter, who received nothing in his will, actually inherited half of his movable property. So no doubt she was delighted with that. The final thing to say is that domicile is a bit of a strange existence in the law. It's about a relationship between a person and a country, and one thing to take away is the reason why it has all of these different strange things being relevant is it's an unusual kind of relationship, close to nationality, where issues of parentage, residence, hobbies, and intentions are all relevant. Thank you. Now, I'm not sure to whom I'm passing this over. It might be back to Charisse. No.
There we are. So I'm Natasha Dzameh. I'll be taking the next topic. Let me just see if I have control of the slides. Yes. So this will be short and sweet, so we should be able to still stick to the end time of 11, well, the question time of 11. So what I'm talking about is propounding a will, and very briefly I just want to discuss the presumption of revocation. So you will tend to come across this particular presumption in two instances. Firstly, where the will has been in some way mutilated. So if the will is found on the testator's death in a mutilated condition and it was known to have been in their possession prior to their death, it's presumed to have been mutilated by the testator with the intention of revoking it. Now, the other instance is where the original is missing. So if it's known to have been in the possession of the testator and there's no evidence of it leaving their custody, but it can't be found on their death, there's a prima facie presumption that she or he destroyed it with the intention of revoking it. Now, in both of those instances, this presumption is rebuttable. So it's something that you can displace by way of evidence, such as the testator's unchanged intention, the fact that the testator had a questionable state of mind, and so on. Dealing with cases whereby someone is trying to propound for a will, and it's in fact a contested matter, there's a very useful case that you should look at to deal with the procedure, and that is a case called Pain and Pain. So in this case, the claimant sought to prove a will in solemn form, allegedly executed by the testator in 2012. Now, the defendant counterclaimed for proof in solemn form of a will that was allegedly executed in 1998. The 2012 will was lodged with the court in accordance with CPR 57.5. The original of the 1998 will was not, however, lodged. Photocopies were produced for the hearing, but they didn't show the complete document. So at first instance, the claim and the counterclaim were dismissed. The judge held that neither will was validly executed. In fact, in terms of the 1998 will, there was no oral evidence from either of the attesting witnesses. The judge held that the will was not signed by either of them as required by Section 9 of the Wills Act 1837, because the names inserted in capital letters on the will, rather than insertion of the signature. The defendant appealed against dismissal of the counterclaim. And so this then went to the Court of Appeal. He said, well, there's no need for a signature in the sense of an identifiable and probably unique personal mark. The requirement is instead for the witness to write their name with the intention that the act of writing it operates as an attestation of the will. There's a strong public interest in valid testamentary dispositions being upheld, and this, combined with the poor procedural history, meant the judge should have concluded that she could not safely pronounce against the 1998 will without the original being produced to the court. Now, that was a serious procedural irregularity, and without an opportunity for oral evidence from the attesting witnesses, there having been none. Now, the original 1998 will was in fact consistent with the oral evidence of the attesting witnesses, and if read as a whole, gave every appearance of being validly executed. Now, those witnesses had given that oral evidence in terms of by the time this matter came to an appeal, and the court pronounced in solemn form of law for the force and validity of the 1998 will. So ultimately, what do you tend to find happens? Well, there's a case that I dealt with, which ended up with hearings that were split across, I believe it was December and February. And this was a case in the High Court in the Chancery Division in Cardiff. And in that case, the claimant sought to propound for a 1988 will, that will having been prepared by a law firm. And what they had provided was an uncertified copy. They were legally represented and they had counsel throughout. Well, they had counsel up until the stage of the PCR, but they had solicitors throughout. And the situation here was that it was either going to be an intestacy, or if the 1988 will was propounded for, there would still be an issue of partial intestacy due to the way in which it had been drafted. Now, this copy of the 1988 will was alleged to have been found amongst the possessions of the testator's deceased brother. So obviously there was no evidence from said brother. Now the three claimants provided witness statements asserting they knew of no testamentary documents other than this alleged will. But in cross-examination, it came out that the individual who had asserted that she in fact found the will had indeed found only one page, whereas the will that was exhibited consisted of 3 pages, 2 substantive pages and 1 backsheet. And again in cross-examination, she could not recall whether what she'd seen had been signed. All she could recall is that she found 1 page, that she had provided it to the solicitors, and so she had no explanation whatsoever as to why there was suddenly a 3-page will exhibited to her witness statement. It was quite a strange case because in fact this particular individual was based in America and there had been no attempt to set up any sort of video to allow for cross-examination. So in fact she had to be cross-examined by way of using the court clerk's telephone, which was quite a strange situation that I've not had before. Now another witness claimed to have been provided with a copy of the will, and she had said, well, she was provided with this copy by the testator's deceased brother. There were also various allegations about whether certain pages might have been stolen from certain properties. So it's quite an odd case. I'm just noticing that my system has crashed, so I don't think I can actually change the slides on this. Let's see. Okay. But going on in terms of what happened next, well, the court looked at this at the first hearing that we had, and so the copy of the 1988 will was not filed in accordance with CPR 57.5. So what had been filed was instead various copies of copies, and so we had a situation where, looking at the pleadings, the will said one thing with various parts being completely illegible, and then during the course of the witness statements coming out, we then received other copies whereby other parts were illegible, but the previous parts had been legible. So it's clear that no one really knew which document had in fact been provided to the solicitors. Now there was no evidence whatsoever from any attesting witnesses, so there's no evidence adduced either to explain why there was no evidence from the attesting witnesses. No inquiries had been made of the solicitor's firm at which the 1988 will was in fact drafted. And so the claim was put off, part heard. The judge said, well, look, realistically, although this is the claimant's claim, the claimant's at this point having no counsel for the trial. And given the lack of documentation that had been supplied on their part in this respect, the judge then placed the onus on my solicitors to ascertain exactly what had been done in terms of the attesting witnesses, to try and locate them and, if possible, procure a witness statement from them. And if not, then an explanation as to why that witness statement couldn't be procured. The claimant solicitors were ordered to file a witness statement explaining their actions in relation to the 1988 will that was originally supplied to them and the various copies in the bundle, because no one could quite work out where the 3-page will had come from. Now, when we returned to court, at that stage, we then had a statement from an attesting witness who confirmed that, in fact, his firm had been taken over by another firm, at which point the testator was written to being offered the opportunity to be a client of this new firm, or being offered, in the alternative, the opportunity to receive her will back. That new firm had no record of her ever being a client, and so the judge took the view that obviously she'd received the will back. Now, in terms of what had happened insofar as the various different versions of the will, the witness statement that came in essentially said the file handler's changed. We don't really know what the other file handler did, and so we really can't offer the court any guidance as to where the 3 pages have come from, who they were sent in by, and so on, which was undoubtedly helpful from my side. The upshot of it was that the court did not propound for the 1988 will. Now, if you have one of these cases, what are the things that you really need to be thinking about in terms of preparation? Well, firstly, you want to think about the overriding concept here is the will in whole or in part valid as a testamentary instrument? So if you've got an issue of the presumption of revocation, depending what side you're on, you're going to want to be proving that the will was in the custody of the deceased. So look at things like whether there is a record of any solicitors having sent the will to the deceased. If you're on the other side, you want to be looking at whether there's any evidence to rebut that presumption. So how did the deceased keep important documents? Did the testator make statements that were consistent or inconsistent with the terms of the will? Is there any other explanation for this missing will? So is this a situation where there could be an allegation over fraudulent destruction? Was there an accidental fire? Those kind of things. Think about those issues. Make sure that you comply with CPR 57.5 in terms of filing the copy. The reason being that it very much seems from pain and pain that if you don't file that, and if there ends up being an issue insofar as lack of attesting witnesses or simply having filed copies of copies, there's a very good chance that what the court will do is say, well, look, I don't have enough evidence here to safely make a decision either way. This isn't the kind of case where the court will simply say, well, you haven't proven your case, and so that's the end of it, the other side wins. What will likely happen is you will go off, it will be adjourned, you'll then have to take various steps, you will come back for another hearing. In that situation, if the court takes the view that one side in particular failed to prepare for this, you will be risking costs. And the thing that you don't want to have is a situation whereby you're having an awkward chat with the client following a costs order that's been made against you, and that's been made purely because you didn't prepare properly for the previous hearing. So make sure that when you're dealing with the witness statements on this kind of thing, that you are providing evidence of due execution. So you want a witness statement from one or more of the attesting witnesses. Otherwise, it may well be the case, depending on how old the will is, that the attesting witnesses are no longer alive. If that is the case, then you need to give the court the satisfactory explanation as to their absence, and then no adverse inference will be drawn. At times, you can in fact use an affidavit rather than oral evidence, but what you don't want is to be going into a trial on this with absolutely no evidence from the attesting witnesses. You also don't want counsel turning up at a PTR, having only seen the witness statements, then saying to you, well, look, have you located the attesting witnesses? Have you made any attempt to contact them? Why is there no evidence in the bundle about this? You don't want a situation either where the will has been prepared by a law firm and you haven't contacted that firm. There's no evidence about that and counsel's asking you about that, because ultimately at the stage of the PTR you would have incurred a lot of costs, and there's going to be a decision that has to be made, which is a risky one as to whether you investigate these aspects now, knowing full well that the issues that come out may well decide against you, or do you run the risk? And I'd say ideally going forward you probably want to investigate them there and then, because otherwise it very much seems from pain and pain that ultimately they will be investigated later. You'll just end up going part held of the trial. Ideally, however, get this prepared well in advance and you won't have that situation at the PTR. Now I would say that I'll hand back over to someone, but my entire screen has crashed, so I'm assuming that there's a way that someone else can take control.
So everyone, that concludes our 4 speakers today. I'm now going to open the floor for questions. We've received a couple of questions in already. If anyone else would like to forward a question following the talks you've heard today, please use the Q&A function on the toolbar. For anyone that doesn't know how to access that, it's the icon in a speech bubble with a question mark. Please note, I won't read anyone's names out, so don't fear for asking any questions. Your identity will be fully protected. So the first question is coming over to you, Alex, and it reads as follows. Can we confirm how if Section 1A of the Wills Act regarding presence hasn't been changed with the testator remotely initiating a will signing, how would we actually therefore initiate a remote signing? Alex, over to you.
Right. I don't think a testator can remotely execute a will because Section 9.1a has not been amended. So presence in 1a still means clear line of sight, not through a video, but in the real world. So I think the best you can do is you can ask someone, if you're the testator, you can ask someone, your solicitor or another third party, to sign on your behalf and at your direction. And relying on Casson and Dade, you can ask them to do that with you looking through the window at them doing it. But what you can't do is ask them to do it at the other end of a Zoom call. So it is unfortunate. You can't, it would have been so much easier if you could arrange for not only the person signing on your behalf as testator, but also the witnesses all being remote at the end of a Zoom call. But that's not allowed for in the legislation. So I think you've got to just think through, how are you going to get this third party to sign on behalf of the testator, either in the room or at least having a clear physical line of sight to them when it happens. And then you start going through the remote witnessing process envisaged by sections 1C and 1D. So I'm afraid there's not an easy answer. It is rather involved, but that's just the way the legislation has been drafted.
Thanks, Alex. So the second question, and Adam, this is coming your way on domicile. So the question reads as follows. Client lived in England for the vast majority of his life and then moved to Scotland much later on in the later years of his life. He lived in Scotland for a year only and then died in Scotland. The only assets he had on death were money in a bank account. Is he considered to be domiciled in England or Scotland? Adam, over to you.
So I think the easy answer is probably a naughty one, which is I can't say for sure. But the cases are clear that it's such a multifaceted question that you really have to delve into the details. I think that's what I was trying to get at when saying somebody's yacht club membership might even be relevant. It sounds to me likely that that person, and I say this tentatively, might still have been domiciled in England, but I think technically the time which one spends in the new country isn't determinative of whether one's domiciled there or not. So if this individual moved to Scotland, had the intention, and the intention is also evidenced in what he did, had the intention to permanently reside in Scotland and made that clear, it's impossible to rule out that he didn't die domiciled in Scotland. That's what I'd say. But I think that the key thing is these aren't easy questions and that lots of weird and wonderful factors have a bearing. I think the shortness of time that the individual lived in Scotland could suggest he remained domiciled in England, but I don't think it's crystal clear, and certainly a delving into the facts would be required.
Adam, I don't know what you think about this, but I guess if you were approaching it going into bat for England as opposed to Scotland, I would probably focus on the question of whether you can demonstrate that there was no intention to return to England at some point in the future, and that burden on the person batting for Scotland, as it were, because I think that's probably the hardest element to prove, and just emphasise that domicile is not easily lost, and coming back to your point of the short period of time. So I tend to agree with you that I would probably come down towards England over Scotland, but yeah, fact dependent, I suggest.
I'm very grateful to my learned colleague this night. I think that is right. Put it on his insurance, I think is what he's saying. The gut reaction is England. Essentially, it's hard to acquire a domicile of choice, and the courts get really into the detail of whether, all the silly things that you've done, but it's not impossible that he's done enough. If he told all of his friends, I hate England, I've had enough of it. English people, I hate them and I have nothing in common with them anymore. I'm going to live in Scotland, the land of my ancestors. That's where I belong. I'm moving everything there. I'm taking everything there, my Scottish bank account, and wearing a kilt all day. Then you've got a case on the hand. So.
Thank you both. I certainly agree. I think domicile is becoming a much greater issue in the contentious probate sphere. More often than not, we're seeing individuals or the deceased having moved typically to France or Spain more commonly in the later years of their life. So I certainly think domicile is an issue we're going to have to grapple with and will crop up more and more in the future. So the next question I have, and Natasha, this one is coming your way, reads as follows. If the only facts were that the original will was known to have last been with the testator and at death it could not be found, how likely is that the court would find that it had been revoked? Over to you, Natasha.
So in that situation, that is essentially your prima facie presumption operating there. In terms of how likely it is that the court will find that it's been revoked, well, if there is absolutely no other evidence whatsoever, there doesn't seem to be any evidence to rebut the presumption, so it seems very likely. However, it seems to me that there probably is some other evidence. So, for example, how did the testator generally keep important documents? Did they keep them in quite a secure fashion? In which case, it's much more likely that this being missing was in fact them having revoked it, having destroyed it. If they didn't, and they were quite haphazard about it, one could have said, well, actually, the presumption is in fact weaker. And so I do think there are other things that you probably want to consider, but on the face of it, it looks like the presumption is certainly operating.
Thank you, Natasha. And Adam, we're coming back to you because I think, as we've just anticipated, domicile is becoming a hot issue today, let alone in the next couple of years. And the question reads as follows. How would you deal with domicile of a British expat who retires to, say, Spain, only associates with other British expats, makes no effort to learn the language and has limited financial ties to Spain? Over to you, Adam.
I appreciate this is becoming domicile day, but I think that what I have to stress is, and I was surprised at how what could seem to be irrelevant factors are borne in mind by the courts. That was the whole point of the yacht clubs in France. The court didn't say to what extent it said, because he was in the Villefranche Yacht Club, he's a Frenchman. You know, that's not how it works. But a whole palette of strange, or perhaps might seem to a man on a galloping horse, irrelevant factors are within the scope of what can be taken into account. Again, I think the narrative which you described, Charisse, that is a narrative certainly seemingly by the questioner aiming at saying he was still British or English. I can tell that. And certainly on that cherry-picked set of information, my intuition is he may well still be English. But, you know, the case where that Irish commander sailor, he had said, and this is where domicile's interesting and difficult, because it's different from nationality, and lay individuals and perhaps even lawyers conflate them. He'd said to his bank manager, I think, I'm an Irishman, I was born in Cork, you know, almost get lost trying to tell me I'm anything other than Irish. But he hadn't lived in Ireland for a huge amount of time. And his nationality, which he was proud of, was always going to be Irish. You can't lose a nationality in a similar way. And one can, I think, in light of that, maintain a nationality and a national pride that's separate from a domicile, which is linked to desire to permanently stay somewhere, an intention permanently to stay. So you, in the example that you gave me, the individual could have been proud of his British or English roots, but intended to live out his life in Spain. So what might seem like, certainly on the narrative that was presented, easy situation, certainly might not be. If he's just got a permanent intention to reside in Spain, the fact that he hangs out with English mates, by and large, may not be enough. But there's a, so I think the real message is gut reactions are good, and certainly the key facts, such as the ones that are passed on, are the ones to be focused on the most. But other issues are relevant, and the minutiae of the life is relevant. And the key question is intention to permanently reside somewhere. And that could be that could take one, in that example, closer to the fact that he's gone to Spain, much perhaps to the questioner's dissatisfaction. Because I know there's a whole thing about needing foreign lawyers to get involved and what's going to happen, and all that is a whole other hassle for us English lawyers sometimes. But yeah, there we go.
Thank you, Adam. And just on that point of domicile, Adam, do you think there are any sort of key factors that trump the other factors when you're looking at domicile? Or do you think it's more tantamount to a course of dealing approach that we're seeing a Talata claim, just taking the situation as a whole and having a feeling of whether there was that intention to permanently never return, or actually they were always going to live there, but they didn't intend to change their domicile? What's your view on that?
Yeah, it is quite a strange area. Certainly everything is relevant. So what you mean by course of dealing, I think that's the way to approach it, is to look at everything. Joss alluded quite rightly to a more technical way that the courts approach it sometimes, and sometimes say that it is actually quite hard to acquire a new domicile. But what that actually means is almost neither here nor there, because it could be that, in the case, as a matter of fact, because of what's happened in an individual case, all of the relevant factors point to the acquisition of a new domicile anyway. I didn't find that it was. I think the courts have this sort of slight angling against the acquisition of a new domicile. That's true, but I think that that's a less helpful rule than the rule that you look at everything in detail. And I think the courts want to see evidence of an intention that you've sort of. And it is this, what I was trying to get at through the talk, it's quite an ethereal idea, an abstract idea, and like you've upsticked and you've settled somewhere else. That's settling the intention to permanently reside. Lord Cranworth's quotation, which is that if you don't know what your permanent home is, I can't help you out very much. That's sort of strange way in which domicile works. So I wouldn't want to cherry pick individual factors, but the main ones, and I think I had two little lists. One of them had clubs, and the other one was moving your spouse there, having your children there, buying a home there, having bank accounts there. They're the main factors, I think, that I would fix my attention on. But I would have a very much all-inclusive approach as well.
Great, thank you, Adam. We have another question, and Natasha, your talk has certainly sparked some debate over presumption, and the question reads as follows. If it is understood the deceased did not destroy her will, but it went missing when she was in hospital and then died, it was then believed her children had destroyed the will to rely on a previously more favourable will. Would these be circumstances where the presumption could be rebutted? Over to you, Natasha.
So the first thing I do is question the certainty over the exact time that it went missing, because it seems unlikely to me that there's been a conversation had with her about where the will is as she was leaving to go to hospital. So it may well be the case that in fact it went missing earlier. But if we assume that we know for definite that it went missing when she was in hospital, then you're probably looking at a fraudulent revocation issue or fraudulent destruction issue that you may well want to argue. It would seem to me that in those circumstances, the assumption of facts that the presumption itself relies on has been proven false, in which case the presumption has been rebutted.
And I've just got one last remaining question, and then I think we'll draw the Q&A section to an end. And Joss, this is coming over to you in terms of lack of knowledge and approval. I think it's quite often an underused ground for most of us practitioners. So if we were instructing someone such as yourself to give merits on a lack of knowledge and approval ground, what is the evidence you'd want to see the practitioners collating to put you in a formed position to make a judgment call how that could play out at court?
I think with knowledge and approval claims, front and centre is the circumstances of how it was put together, and how it was, more importantly, how it was signed. As I said, these are perfect grounds for dodgy will cases without the involvement or presence of solicitors. And as we saw in Milton and Borman, occasionally for cases where you do have solicitors, but there's a heavy third-party influence in the meetings at the time. So it's all about minimising or showing the lack of input from the testator at the critical moment when the instructions are given, and B, latterly when it's signed. So in that context, I suppose it's very similar to an undue influence claim, because you're really getting down to the nitty-gritty of how much they were involved and had a free intention and knowledge at that particular time. But you're always butting up against the difficulty of, if you've got a solicitor involved, if the solicitor is taking instructions, particularly just with the testator themselves, it's very difficult for then the court to turn around and say, actually, even though they told the will drafter what they wanted, they didn't really know or approve it in any meaningful sense. Milton and Borman gives a route through that, but basically, I mean, my final tip in this is what you also see in any successful undue influence claim, is you've got to make the judge really hate the other side, and you've got to make the judge think that they're up to no good and that they've been, manipulating the deceased and in all kinds of ways. In Middleton and Borman, there were lots of allegations of the grandson taking money, and the judge said again and again, look, I'm not here to decide this, but it's interesting. And you can tell, the tenor of these judgments, Schrader and Schrader and Edwards and Edwards in undue influence, is that the judge just didn't like the propounder of the will, and that's going to give you, although it's not the test and not strictly relevant, but if you can put forward their personality and get that front and centre of your application, that's going to stand you in good stead. But ultimately, it's still going to come down to the factual matrix around the instructions and the signing.
Thank you, Joss. So I think we don't have any more questions being uploaded, so I'll bring a close to the question and answer section. Thank you everyone for joining today, and thank you also for uploading your questions. We hope you found the talks informative and of use to you. Please do take the time to complete the feedback form. It's been uploaded to this session and there'll be a link in the email that follows it up. It will just enable St John's Chambers to look at further seminars and topics in the future. If I was in a position where I could do a university challenge goodbye from all the speakers and myself, I would take on that role, but I can't. So it leaves me to say thank you everyone for joining and participating today, and I hope you have a very good Thursday. Thank you.